You just can't seem to follow the rules. She kept chasing me. That's it. And then she's gonna talk about calling the police and all that. She control thing she's trying to do. That's it.
I don't care what it is. You have got all of these charges. You just need to just stop.
Get ready, because today's court hearing takes a serious turn. Judge Simpson is presiding, and the defendant in front of him is facing some tough questions. This man is accused of tampering with his ankle monitor, an even more troubling meeting. Up with a woman he was previously ordered to stay away from due to a domestic violence case. That's a clear violation of his bond conditions. The judge doesn't let it slide. Judge Simpson makes it clear if you're out on bond with restrictions, especially with a tether device, those conditions are not suggestions. Breaking them puts your freedom at risk. The defendant tries to offer explanations, but it's clear from the...
Thank you, Mr. Burgess.
And Your Honor, I believe he's been arraigned. Well, obviously he's been arraigned. The PE is scheduled for tomorrow morning. I believe.
On the one case, I have a new case. However,
I was unaware there were new charges, Judge. But I don't know if this court's prepared to arraign my client.
I am.
Okay.
And I don't know.
You're going to stand in for the purposes of the arraignment.
I'll be filing an appearance, Your Honor. I was unaware, but the charge, I would have filed one already.
It's a charge of interfering with electronic communication device, a 2-year felony, and also domestic violence, second offense, a 1-year misdemeanor.
Yes, Your Honor. As it relates to both those charges, waive any further reading of the warrant. Stand mute to both those charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. I'll set a probable cause conference in that case for on form, please. For November 14th, 2024 at 9 a.m. or as your invite indicates. As to bond in that case, what is that?
Yes, Your Honor. Obviously, Mr. Carter's here on his own voluntarily this morning or this afternoon. And obviously the court knows his history of appearance in front of this court. Your Honor, he just got a new job. He was, unfortunately, he lost his other job due to this incident, but he just got a new job that he'll probably lose if he's in custody. Judge, it does appear that the complaining witness in both these cases is the same person who has actually reached out to me before, Your Honor's indicated her, I believe, unlikeliness of appearance in the case. I don't think she wants to proceed with the case, but that's my understanding anyway. People might have a different position, Judge, but she's reached out to me independently and indicated that she does not want to proceed with those charges. But be that as may, Your Honor, I don't believe my client's a flight risk, and he is on. And what's that? Still on a tether, Your Honor. He did post a significant bond in the last case. Understand these are new serious charges, Judge, but I'm asking the court to consider a nominal 10% bond, if not a personal bond.
Start, he's not making a strong case for himself. To be fair, the defense attorney is doing everything he can, but the facts aren't on their side. The judge had warned the defendant before, and instead of following the rules, he did the exact opposite. It's like ignoring a clear red light and acting surprised when you get pulled over. Judge Simpson isn't interested in excuses. He's there to enforce the law. It looks like this man is about to face the consequences. Things only get worse when we hear more details. There's a restraining order in place, and the defendant was told directly to avoid all contact with the woman involved. Not a suggestion in order.
Anything from the people.
Your Honor, I have some advantage because I do have the police report for the newest case. Mr. Burgess does not, but I will indicate to the court a few things. First of all, this court arraigned the defendant on not his newest felony that he was just arraigned on, but the one that's set for preliminary examination tomorrow on October 7th. At that time, the defendant was ordered not to have contact with the victim, Jennifer Matlock. The new date of offense, the newest case that we're here for today, that the defendant is alleged to have committed is October the 20th. Later, and I will tell the court after reviewing the police report, the person representing himself to be the defendant did have contact with the police officer and admitted to having contact with the victim. Denied the assaultive behavior, but didn't admit to having contact with differ. Now, because the police officer was the defendant face to face, I cannot say with absolute certainty that it was the defendant. However, the police officer did a very good job in their report of detailing how he came into contact with that person, that this person kept called him back or presented themselves to be the defendant, and said that he would turn himself in for the bond violation. I don't have a record that actually happened. So Your Honor, in any case, this is somebody that was on the score for probation, on bond for a felony, and now has picked up another new felony. So I am asking the court to follow probation's recommendation, both the probation and sentence the defendant to serve a balance of this time. And in bond in this case, we're assessing for $100,000 for the felony.
Court will order as a condition of the bond that there's to be no possession of any alcohol, illegal drugs, or any recreational marijuana. Better, I'm not entirely sure what is going on with you in that regard. I ordered you on the 7th not to have contact with this person. And then, lo and behold, we end up with this case occurring less than 2 weeks later. Tried to give you every benefit, and I understand there are only allegations, but try to give you the darn benefit of the doubt regarding everything because of at least the way that you conducted yourself in regards, particularly regarding flight risk. But you just can't seem to follow the rules.
Your Honor, I'm sorry. I don't mean to interrupt.
Go ahead.
Sorry, Judge. Judge, the incident on the 20th, based on conversations I've had with my client as well as the complainant in this case, the complainant approached my client, asked for a phone back he had purchased, but it was in her name, which he returned to her. That was the basis of the contact. That's our understanding of it, Judge. So I wouldn't.
Right. But the thing is,
I know.
He needs to be turning around and running in another direction. He shouldn't even be having a conversation, shouldn't be doing anything whatsoever. I don't think it's at all unclear as to anything that this court has said to you regarding what you need to do. And you need to just follow the rules. I gave you a break the last time that you came in. Even after that, let you go.
Still, he met up with her, knowingly breaking that rule. And now, in court, he's trying to explain it away as a misunderstanding. It's hard to believe anyone would think that excuse would work. Judge Simpson listens carefully, but it's clear he's not buying it. This kind of violation isn't just careless, it's serious. This case is a reminder of why court orders matter. Mistakes happen, but when someone repeatedly ignores warnings, it shows a pattern, and that's exactly what Judge Simpson sees. This defendant had a chance to follow the rules and stay out of trouble, but instead he made it clear he doesn't. Take the law seriously. Judges deal with this kind of behavior.
She put up on me. I was in the room playing my game, and she came in the room.
And then you get up and leave.
She kept chasing me. That's it. And then she was talking about calling the police and all that. She's chasing me. She's chasing me. She's chasing me. I hopped in my car, and that's when I pulled on.
Well, maybe that's all going to come out, Carter. Maybe that's all going to come out. I let you out the last time. Should have, of all rights, locked you up on that date. Didn't do it. Gave you the benefit of the doubt because of the time that you came back after you were inadvertently released by the jail. And then what happens? I end up, you get that other case set for exam. Then what ends up happening? I get here, and you've got another case.
It's a control thing she's trying to do. That's it.
I don't care what it is. You have got all of these charges. And you're the one under the jurisdiction of the court. So however you got to figure it out, you need to figure it out.
Yes, sir. Yes, sir.
Defendant's bond on that case would be set in the amount of $100,000 cash surety. On his other matter, anything you want to say before I propose sentence on that case?
I want to say, I tried my hardest. I tried my hardest to do right. I tried my hardest to stay away from women that want to see me in jail rather than see me elevate myself. So, I mean, I understand. I understand. I understand. I understand it. When I get out this situation this time, I'm by myself. I just,
You know what you ought to do, Mr. Carter, and I don't mean to interrupt you. You have the right to allocate, but I'm just going to tell you something. You ought to quit blaming them. You just need to just stop blaming them and thinking that they're the ones that stop you from going anywhere. Because, young man, that is not the case.
Yes, sir.
You are smart enough. You can do whatever you want to do. You can stay away from whoever you want to stay away from. Problem is, quite frankly, you're just being stupid. You're just playing games, and this is what happens. You end up in jail on a $100,000 cash bond, and you're about to go now.
I'll take full responsibility. I appreciate it.
Anything else you want to tell the court?
Sir.
Judge, I don't know if it would have any impact on the court one way or the other, but I don't know if the court wants to wait to see the disposition of those cases, or if you're just going to follow the recommendation.
I'm not gonna wait. If there becomes a certain disposition regarding those cases, certainly I'll take that into consideration in modifying his sentence on the case. But I'm not gonna do that at this point in time. I keep giving him breaks, keep doing everything, and he keeps just coming back to this court, disappointing this court, and ending up with more charges, just time and time and time again. And so, in that respect, I'm done. I'm going to revoke the defendant's probation. He is to complete the in-jail on farm program while he's incarcerated. I'm going to waive all remaining terms except the financial obligations on this case, discharge the defendant from probation without improvement. I will sentence the defendant to 365 days in jail, credit 162 days served. The defendant is to serve the balance.
Your Honor, the court ordered the non-farm program. Probation also requested the DV program. So if you just requested DV, the court want the defendant to perform both or just one or the other?
I should have said in-jail DV program. That's what I meant to say. Thank you. Defendant's remanded.
Behavior far too often, and it wastes valuable time that could be spent helping real victims. Violating a restraining order is a criminal offense, and the more violations, the steeper the consequences. By the time the defendant finishes his explanation, it's obvious the judge has heard enough. Judge Simpson stands firm and does what the law requires. That wraps up today's courtroom drama. What did you think? Was Judge Simpson too strict, or just doing his job? Let us know your thoughts, and if you're interested in more real courtroom moments like this, make sure to subscribe. Thanks for watching, and see you next time.